she made on account of the mortgage outside of the normal monthly payment.
I think there might be some obligation on the lawyer in drafting a contract of that type to point out to the client that they represented that contributions of that type are made at their peril if there's no
I think that's really important, and it's not just in the matrimonial home, but in any circumstance where one piece of property is going to belong exclusively to one of the parties.
One of the other areas where contracts are frequently discussed is in the context of excluding certain business assets. Steve Smart has prepared for us 4 sample contracts in the materials, and perhaps he could outline the basics of those.
Okay. Ross asked me to bring to this meeting a draft contract whereby business assets are excluded. And of course this is a very common request, and it's a very major issue that we deal with in negotiating marriage contracts. In thinking this out, what I realized without knowing it is that there really is no standard way of dealing with this issue at this point in time by way of contract. And as I found out, there's in this area many ways of skinning the cat. And so I've got 4 contracts, and I want to go over them very briefly with you just to give you a sense of different approaches to this very important area, and one that will cause you'll be asked to deal with on a number of occasions. If you turn to page F81, I'm going to run through these contracts very quickly. But one of the, this contract in fact does not exclude the business assets, but I thought it was important to show you a contract that goes less far, because you're going to find in many cases you're not going to be able to achieve a satisfactorily negotiated contract excluding the business asset. So picture yourself in this situation that you're a law partner and your spouse, you're asking your spouse to sign off any interest in the law partnership, and this example doesn't accomplish what you want, but it accomplishes certain other goals. It is a limited use contract. If you turn to page F84, we put right in the contract what the limited purpose of this contract is, and it's to limit the right of the wife to compel and the obligation of the husband to make production of documents, so that no firm document will be required to be produced or its contents disclosed in a legal proceeding between the husband and wife. 2, to exempt the interest of the husband in the firm from seizure and execution of any judgment or entitlement that the wife has or may obtain against him. So right away, the object is not to cut out her right to an interest, it's to try and reduce the area of exposure in terms of producing documentary information with respect to financial affairs, and to make sure the law firm itself does not become subject to seizure. If you go down to paragraph 7 on that page, what we have here, it's entitled Value of Interest in Firm for Husband's Net Family Property. It clearly contemplates there will be a valuation, but it fixes how the value is to be determined, both at the date of marriage and on the date of the valuation date, the date of separation. So there's a formula that's agreed by way of contract that as of the date of marriage, we will agree that we will value my interest in my partnership this way, and it has a formula there. And of course, the formula will vary from business to business. And sub B is the value on the date of separation. Now, if you turn to the next page, F86, financial information relating to the firm, if there is a breakdown of the marriage, in lieu of the production or disclosure of any firm document or documents upon the request of the husband, the administrator, who is a defined person for the purpose of the agreement, will deliver to the husband a letter addressed to him furnishing the following information. And it specifies the kinds of information that are used to, in fact, fix the values at date of marriage and date of separation. And to repeat, the concept is to cut out a full disclosure of the law practice. It's to fix only the interest of the particular law partner, and to diminish access to overall information. Sub 2 is important. The wife will accept the letter delivered pursuant to sub 1 in lieu of any right she has or may have to inspect or compel the production of any firm document. 3, the wife will maintain in strict confidence all financial information relating to the firm, including any information obtained pursuant to the section called financial information, which she may become privy, provided that disclosure of such information to a professional advisor or to court in connection with the determination of a dispute between the wife and husband shall not result in a breach of this agreement. Now, the next paragraph confirms again that the above information is what she gets, and she doesn't get further production. But paragraph 10 makes it clear that nothing in this contract will limit the entitlement of either party to an equalization. So this contract, I thought I'd just offer it to you as an example where when you can't get what you want because the other side, there are certain objects you can still achieve by way of a marriage contract which may be of real benefit to one of the parties, and namely by fixing values dealing with financial production. Note on page F88 that even though we haven't come to any substantive terms in terms of losing rights to make the full claim, it's just the financial information, you've still got to have financial disclosure for this kind of a contract. Because we know any marriage contract, if it's going to be valid, there has to be the requirement of financial disclosure. If we turn now to the next precedent, which is at F91, we're going to wade into the water a bit further. And we're going to have the same kinds of provisions about limiting financial information, but now we're going to exempt out certain property. And under limited purpose of contract, F93, the purpose of this contract is to restrict the rights and entitlements of the parties that they have or may have if there should be a breakdown of the marriage, if one of them should die, leaving the other surviving. The restrictions on the rights and entitlements is limited to excluding the following property and its value from net family property, the husband and wife. And sub-item 2 is the corporate assets, so the business interests. In this contract, they're not defined, at least there is a definition in the definition section, but no companies are specifically named by name. And then 3 and 4 are what we've seen in the previous contract. If you turn the page to 94, number 1, each party acknowledges that B, the corporate assets are owned absolutely by the husband. Number 2, each party by this contract agrees with the other. Under B, the corporate assets and their value are to be excluded from the husband's net family property for the purpose of determining any entitlement to an equalization of the Family Law Act. So, and on paragraph 11, it'll then summarize that will be sort of a summary of the contract. Nothing in this contract will limit the entitlement of either party to an equalization of their net family properties or to a division of property under the Family Law Act or to any other rights under Part 1 of the Act as may apply to property and the value of property other than, and then in B you put in the corporate assets. So that's the second contract that I want to show you as a technique of avoiding the corporate assets from being included in the net family property calculation or their value. Precedent 3 is an example, and I've found that this has happened a number of times in negotiations that I've not only originated but come from other solicitors, is you get back to the old concept of family assets and non-family assets. In other words, we're opting out of Part 1 of the Family Law Act. We're just opting out of a system of talking about not net family property and so on. And we, by contract, agree that certain property will be family assets and other property will be non-family assets. In other words, a return to the old Act in concept. But in the definition contained at page 100, family assets really comes pretty well from the old Act. It's the definition that was contained in the Family Law Reform Act. And to some people, this is not a bad way to settle their affairs. And the question is, in overall, this contract is going to be, we're going to share the family assets equally, and the other ones will depend on ownership. And of course, what we're going to do in this contract is we're going to put the business interests in the non-family assets. And that way we exempt out the business, whether it's a law practice or a manufacturing business and so on. I won't go through that contract in detail, but it's just, I want to point out, there's no reason you can't go back to the old concepts of family assets, non-family assets once you're in the area of negotiating marriage contracts. You can do whatever you want and what's appropriate. Finally, I'll turn to the fourth precedent, and really, I'm just doing 4 contracts because I want you to understand that there is no tailor-made and right way of doing this. This is the first one that really gets into identifying the business in the second preamble, whereas Harry has been engaged full-time during their marriage as a businessman, being part owner of H&R Green Manufacturing Company together with his brother Richard, and Susan has been engaged full-time since their marriage as a homemaker and mother. And whereas it is desirable to ensure that the company is not adversely affected in the event of the breakdown of marriage. If you'll turn over the page to page 112, the operative sections that we're interested in are paragraphs 3 and 4. No claim affecting the company is 3. Susan will not make any claim for an equalization of net family property or for support or maintenance under the Act or under the Succession Law Reform Act, which will in any way interfere with, encumber, or affect the company or Harry's interest therein. Without limiting the generality of the foregoing, Susan agrees that any claim she may have to an equalization of the net family property under the Act is not to be satisfied or enforced by the transfer to her of any interest in or the issuance of any shares to her, and so on. So it's a very simple contract. It's very short. The object is to pull the company out of the sharing provision. And paragraph 4 goes further, that if the wife's claim cannot be satisfied from other assets other than the company, the wife waives the shortfall and can't then go against the company to satisfy the full claim. Because naturally, while you exempt the company from the sharing, there may be sufficient other assets or there may not to satisfy Susan's claim. But in this case, we're waiving Susan's right to any shortfall that's not available to be satisfied by the other assets. So in conclusion, I just, there's just a number of ways to approach this issue. There's no standard way. You can use your imagination. These are 4 quite different contracts. Thank you.
Stephen Grant, assuming you were representing the other party to one of Steve Smart's proposed agreements, and assuming you weren't dealing with excluding the regime.
I tell him or her not to sign. That'd be the first thing I do.
Assuming you were then presented with the ultimatum that she was going to sign, do you provide for anything in respect of her potential contribution at some point in the future? Let's assume that perhaps she will, there's a possibility she will work in the business. How do you deal with that?
I think it's difficult to provide in a standard form for the contributions, and I think it's more difficult to quantify what benefit or those contributions will be and what remuneration there will be for the contributions. So there are a couple of alternatives to that. One is that the spouse who is making the contribution has to get paid as he or she goes along, or else consider that the contribution is likely to be considered a gift. The second alternative is not to make any contributions, which sounds draconian, but it may be the only answer. Thirdly, you could provide that if there's going to be a contribution to an asset, that before the contribution is made, the contract itself would have to be amended. And I think those really are the alternatives. It's something that you might want to consider, that if this contribution issue is likely to be a factor if somebody's going to work in a business or work on a house or on a boat, that you might want to set out in a detailed reporting letter this advice that you've given about contribution.
Steve Smart, there are certainly cases where a spouse has the ability to control the operations of a company, and where one might be concerned perhaps that if you exclude the company as an asset from sharing, that the husband will then, or the spouse will then, use that as an alter ego in effect to conduct his business that he might normally conduct in his own name. How do you prevent against that problem?
Well, Ross, I think if the situation is that the company really is the primary asset, and you're acting for the wife and you're trying to protect her so that she doesn't lose everything by signing this contract, there are some, I guess the first advice is this may be one situation where you clearly should recommend that your client not sign a marriage contract, because if the company is the main asset and there really is very little else, I think you may have to come down very hard in a situation and not let a contract go ahead. Now, if you're in a situation where that's unrealistic for whatever reasons and there has to be a marriage contract to this couple who are about to be married, there are 1 or 2 other things you can do. But just so we understand the problem, it could be a lot of assets that normally would be family assets or assets that were acquired after marriage, but the husband, just to protect himself, buys it in the company name, and it could be the condo in Florida that's bought in his company name, it could be the car they drive. And I guess that's what Ross is wondering. If those are then company assets, then the wife is not going to be able to get anything because the company is exempted. One of the ways you can deal with that is that you could define, you could have a definition in your contract that would exempt the corporate assets, except those corporate assets that are used as part of married and family life. I mean, you could you could pull out just what the husband was trying to do. So that things like housing, vehicles, and so on do not qualify as part of the corporate assets that are exempt. That's one possibility that I could think of. Another technique you might do is to get a contract that only clearly fixes the value of the company's interest as of the date of marriage. In other words, we come to an agreement right now as to what he's worth and that company's worth, and only exempt that, so that the corporate, the increase in corporate value is not subject to the exemption. I don't know. I think if anybody, it's a very difficult issue, and it's complex because of the nature, the difference between capital and income and so on. But maybe some others would have some. I have some difficulty in providing true protection to such a waiver.
I think it's probably the most problematic where the company is owned solely by the husband, say, or by the spouse, because then he or she has absolute control over how money is going to be handled within the business. It's perhaps less of a problem where the company is not under his, shall we say, complete control. And one of the things that I've done is to differentiate between, as Stephen says, capital and income. Usually you'll see that the owner of the business wants to insist on a clause that will exempt not only the business today, but any appreciation or accretion in the value of the shares and the value of any shares purchased with the shares of the business. And what I've done is to differentiate, as I say, between capital and income, and look at what is exempt is essentially the capital portion of the business, what the business itself or its shares are being transformed into, whether it's the purchase of another business, whether it's the purchase of shares in another business, whether it's the split of the shares in this business, rollovers into related companies or whatever, but that would be exempt from sharing. On the other hand, the husband is likely to receive money directly from the business, whether that's by way of salary, management fees, dividends, or whatever. And what I've said is that assets purchased with income that he receives from the business, whether that is by way of salary, bonus, dividend, management fee, or whatever, that those assets and the value of those assets would be shareable. It's not 100% protection, but I think it may be the best that you can do with a difficult situation, because if husband wants to shelter assets in the business, it's really problematic for the wife because she can end up sharing without having nothing at all. Another thing that you may want to consider is specifying certain assets as being hers regardless of ownership. Matrimonial home is a simple one. Husband may be prepared to pay the value of the matrimonial home to her in order to secure the inviolability of the business, and that's one way of doing it. It's an imperfect solution, but I don't think there is a perfect one.
Thank you. The third type of contract that we would like to deal with before the break, and the one that I think is one of my favorites, is the I love her dearly, but I'll never give her a nickel contract. This, I think, is the third most common area where usually someone who has been burned before and perhaps suffers from some emotional illness, comes to see you, and they're the type of person that you know if you blow the drafting in the contract, you're going to get a letter from the Law Society for sure. Stephen, dealing with that type of a client or that type of a situation, and assuming you're going to be getting a release of support in one of the clauses, do you think those kind of clauses are going to be upheld, or should they be dealt with?
We have a philosophical difference of opinion on this particular point. My view is this, that if you can restrict a contract to dealing with property only, I think that the efficacy of the contract, the ability of the contract to withstand judicial scrutiny will be much greater than if you include other things. I generally tell clients that, as far as I'm concerned, and we don't have much guidance at this point to know this, but my feeling is that at this point contracts dealing primarily with property will be okay. 99%, if you will, and proper. But once you start getting into other areas like support, and even further down the issues dealing with the raising of children, for example, I think that the contract itself becomes much more susceptible to being overridden or set aside. So, as we'll discuss in a minute, we can try to formulate precedents to include, but my own general practice is if I can keep support clauses out of a contract, I try to do it, relying on the fact that I think by and large the rules governing the granting of support are becoming very finely honed and to an extent that we can predict with some certainty what a spouse is likely to get in any set of circumstances.
Steve Smart, do you have any comments?
Well, I think I take quite a different approach, and I think I strongly disagree with my friend Steve here for two reasons. Number one is the Act itself clearly contemplates and provides the right to deal with the issue of support in marriage contracts and doesn't differentiate that issue in any way compared to property. And therefore, from a legislative legal viewpoint, there is no reason to not embark in contracts that deal clearly with release of spousal support. Secondly, very often this is what your client wants, and that's the other reason I do it, because the client is very strong and clear that this is an object of the contract, and we proceed on that basis. Now, I know an argument, we know any contract can be reviewed by a court. We know that. But there's no reason to believe just because we're dealing with support it's going to be any more reviewed than any other contract. So I approach this, I think, more openly. Sometimes, it depends on what you do in the support clause, but sometimes in negotiating, as opposed to a release of support clause, there is a provision for support, and sometimes wives can get a hell of a lot better deal in that contract than they might otherwise have gotten or get according to law. So there's no reason not to look fully and fairly and confidently at that area and negotiate in accordance with instructions.
Ross, I think another thing is, on the one hand, I agree with Steve Brandt when he says don't do it when you're dealing with a young couple. And so many different things can happen during the course of the marriage before the marriage breakdown that it's very, very hard to predict whether what you're doing today is going to be fair or turn out to be unconscionable. I think it's a very different story where you're dealing with a middle-aged or an elderly couple who are on a second marriage and you have a clear idea of what their assets are, and there it's often very easy to have a support release that you can feel extremely comfortable with because you can predict, I think, more realistically what the future may hold for them and what their financial abilities may be.
I'd like to sound a note of warning, however, to those of you who do draft clauses of that type. Reading Professor Bala's paper before the program, he points out specifically that if you do put in a clause which says she will get or he will get a certain amount of money, unless you exclude Section 35 of the Family Law Act, the spouse, when the person becomes a spouse, can simply file that contract in provincial court and then many years in the future come along and say, well, but there's been a material change in circumstances. So if you are going to, or ask for indexing, but the material change clause is the one that worries me the most. So his opinion is you can exclude that section by clear wording and good draftsmanship. But I see another situation where Mr. Epstein's caseload will be increased if clauses of that type are not averted to.
Indexing is something that you might want to consider in the context of a fixed support amount, and that's often something that husbands want to do. They want to say, I want to know exactly what my obligation is going to be if the marriage breaks down. I'm prepared to pay X number of dollars a month on marriage breakdown. And one of the things that you should be considering is the indexing of that amount, because as you know, what X number of dollars is worth today may be worth far, far less if and when the marriage breaks down. And it may break down by reason of death rather than by way of separation, and it may be a debt of his estate. And I think you should consider having an indexing factor to kick in, calculated yearly on the figure that you've calculated today, so that on marriage breakdown it will be an indexed figure that the surviving or the other spouse receives.
Steve Smart, do you have a comment?
In dealing with, we'll call it the husband, I suppose the wife in the situation just because it's statistical, who's uptight about dealing with the issue of maintenance and doesn't want to give maintenance. In a way, I hate dealing with or negotiating these kind of contracts because it really seems like a marketplace, but it does. I've done it a number of times, and I've seen other contracts where you do negotiate maintenance, and the level depends on the length of cohabitation. And I mean, it just sounds so crude, but the fact is, you can get into that area, and some husbands are quite prepared to pay X dollars if we last up to, or nothing up to 5 years after that, X dollars per year for so many years. If we last longer than 10 years. And it really sounds crass, but quite frankly, there are contracts being negotiated that way.
It is crass.
Steve Grant, you drafted some contracts, or some provisions for contracts that you wanted to refer to.
If you could turn to page F19 with me. I, for one, am rather pessimistic about what it will take to have a judge intervene and override a domestic contract. But given my reservations that I just told you about, I've done three options for types of contracts in dealing with support. The first, this is the one that if you're going to exclude support forever, this one I like because I've tried to cover all contingencies here, and what it provides is in the event of a breakdown of a marriage, each party releases the other from all support, and it says that the parties realize that their circumstances may change, and I think it's important to acknowledge this, whether by reason of their health, the cost of living, their employment, the zodiac, or otherwise. I put that in because you never know what circumstance some judge may say that the parties didn't contemplate, so I was just trying to be prudent. And I then say no change, whether in the marriage or otherwise, and I've now strung out some adjectives, but I think you'll find all of these in some case or other to try and say, well, the party, I know that the parties weren't concerned about a profound change in circumstance, but this is a radical change in circumstance. That's different than a profound change in circumstance. So I've strung out these adjectives and then added a little basket clause to throw in any other adjective that might be floating around. And finally, what I've tried to do in this clause is to say that even if some judge unwarrantedly interferes in this, that the parties will have the right to sue each other in damages by way of indemnity in case support is granted. So I've not relied strictly on the contract, but I've given them a right, apart from the domestic contract, I've given them a basic contract right in damages. So that's as good as I could come up with. Now the problem with putting this in precedental material is it'll show up somewhere. I just assume that nobody blame me for this. But the option two, this is the one Steve Smart talked about, and it. I too have seen contracts and have sadly participated in ones that provide for a certain amount of support depending on the number of years of marriage. But I think that to the extent that any of these clauses have any ability to withstand scrutiny, this will be okay. And this clause is really designed to say for each year or each month of cohabitation during marriage, and I took that phrase out of the Act. That's what I call the reimbursement period, because that's what it seems to me to be, sort of reimbursement for the years of cohabitation in the marriage. The spouse will get X amount of dollars. The third option is for a limited time, and kidding aside, I actually think that there may be something to this one. If somebody is giving up an opportunity or a right, not a right, but an opportunity or an ability or some way in which he or she is earning income, you may want to provide for that spouse to have some type of employment rehabilitation, just as support orders are tailored now or can be tailored judicially or by agreement. You may want to provide that in the event of a breakdown that one spouse will pay the other two a certain amount of money to get back into the workforce. I personally think that in this context, there's nothing wrong with a statement of purpose being utilized to set out exactly why this support is being paid. You're putting a potential judge on notice that you turned your mind, you averted your mind to the consequences of a separation, and you are specifically providing for that spouse to reintegrate into the workforce. And to the extent that any of these can stand scrutiny, I think that this one may do it.
Thank you. Ruth, over to you. Can you ever recommend to anybody in all of the precedents that we've been dealing this morning that they sign one of these contracts? It seems to me that for what one side is gaining, the other is losing, and it may be incumbent on the lawyer to simply say, don't sign.
I'm not sure if it's up to us to say don't sign. I look at it as a question of choice, and if the client is fully aware of what he or she is giving up and says, I don't care, this is what I want, then it's not up to me to say, you're a stupid fool to do it. It's not my marriage, it's not my choice. I think there are some contracts which are so one-sided and give so little that you may feel more comfortable saying you are very foolish to sign this, and if you do so at your peril. Circumstances where I'm more comfortable is where the contract has come out of a shared philosophy of the parties. For instance, they may be well aware of what the philosophical basis of the Family Law Act is, and they may say, for us, that's crap. We don't like it. It doesn't apply to us. It's not how we think. It's not what we believe marriage should be. And they structure their own deal, which is something quite different. They may feel, for example, and this is quite common, that because of the odd treatment of the matrimonial home in our legislation, I think there are certain injustices, and many couples are quite prepared to say, look, we inherited the matrimonial home, my husband inherited the matrimonial family, it has nothing to do with me, it should be his and it shouldn't be shared, or he owned it or I owned it prior to the marriage, it shouldn't be shared, and I don't have any difficulty there in saying go ahead and sign. To get back to covering ourselves, as Phil talked about this morning, it's very important to set out in your reporting letter that you've advised them as to what their entitlement would be without the contract, that you've advised them that they're giving something up, and that as far as you are aware, I always put this in my opinion, you understand completely everything that I've told you, and you are freely choosing to sign this agreement for what it's worth. They'll come back and they'll say they didn't know what the heck they were doing, and I pushed them into it. But I think that's about the best you can do in terms of protecting yourself, and also making sure that the client clearly understands what he or she is giving up.
Stephen Grant, dealing with the property issues in contracts where the parties are agreeing to remain fairly separate entities, you have a clause that deals with ownership of property acquired during marriage, and that's the sort of clause that seems to crop up frequently in marriage contracts. Do you see any problems with including a clause of that type?
No, I think you can include a clause dealing with ownership or obtaining of property during the marriage. I think as I look at it again, what you ought to be is more specific about clauses that deal with property that you acquire. If you're going to acquire it jointly, does that mean jointly 50-50 or jointly in accordance with the contribution that you're going to make? And I think if I were to look at it again, I might want to be more specific about property that the spouses intend to acquire and how, in fact, that's going to be held in a marriage.
How do you deal with gifts?
Well, gifts are interesting because you may want to, in your contract, opt into gifts being excluded, if I can do it in a tortuous sort of way. And under the Act, of course, under the Family Law Act, gifts are included in a spouse's NFP unless they're third-party gifts. And I think that's right. And
this is the one where you can give your spouse anything, you get at least half the value.
That's right. Normally, you give your spouse something, and it shows up later to your benefit. So you may want to, in your agreement, provide that gifts or the value of gifts given inter se between the parties in the marriage will not be included in their NFP at the time of the dissolution or the breakdown of the marriage.
What do you do about reporting letters, or do you do them?
Well, I'm very bad about it. Ross asked me specifically because I'm probably the worst on this panel in reporting letters, but I think that I suppose it's advantageous to protect yourself from future suits, and no doubt there will be some, to include as much as you can some detailed explanation as to what the clauses mean. I was looking at the agreement which I use, and I disclaim it only to say that I didn't draft it, but I like a lot of the clauses that it uses. And I think as I look at it again, in contradistinction to the separation agreements, which I think are generally, we become familiar with them and they're readily understood by clients, that the marriage contract and what it entails will be less understood now and maybe for some time. And so I suppose the prudent thing to do is to provide in a reporting letter a short detail of what each of the clauses means. It may be more work, but it may be prudent in the end to do it.
We'll be back in 15 minutes with the balance of the program. I'd like to move on to cohabitation agreements. Harold, given the fact that unmarried spouses who enter into a cohabitation agreement are not subject to the same property considerations as married spouses, what different considerations have to be addressed in drafting a cohabitation agreement?
Well, that statement is probably only partially correct. The cohabitation agreement under the terms of the Family Law Act automatically becomes a marriage contract unless the parties contract out of that provision. So that when drafting the cohabitation agreement, you have to address your mind as to whether or not you're going to want to have this agreement cover the situation if you're married. But some of the differences between a cohabitation agreement and a marriage contract, and probably the most prominent one, deals with the disposition of the matrimonial home. As we all know, parties to a marriage contract are precluded from opting out of the part of the Family Law Act dealing with possessory rights and alienation of the matrimonial home. That restriction is not there on parties who are entering into a cohabitation agreement. What you have to bear in mind, though, is if the parties do not enter into another agreement after executing the cohabitation agreement, that provision dealing with the matrimonial home will become void and perhaps will cause other problems with the agreement.
Yolanta, there are a significant number of cases where the spouses express a desire to be governed by the old regime. We heard Steve Smart mention that in the last hour, where they decide that assets that were commonly used and enjoyed and shared are going to be shared, and that non-family assets as we knew them will not be shared. What sort of benefits can you see in drafting that type of a contract?
I think in a situation where you want to deal in a simpler way with, for example, division of household contents on breakdown of a marriage, this provides a useful scheme. In the precedent that I prepared, the agreement provides for household contents to be divided in kind. Another benefit is I think a lot of people would be more readily willing to share equally a matrimonial home to which they've both contributed, even if the contributions haven't necessarily been equal, because they see it as an asset that is going to be treated somewhat differently than a business asset. I think the major concerns in that kind of scheme is you have to be very careful about defining your assets and ensuring what is or is not going to be included in the definitions of family and non-family assets.
Harold, what sort of downside aspects do you see to going back to the old regime?
Well, I have great difficulty with it. I don't understand why one would go back to the uncertainty of the previous legislation. If what the contract is designed to do is to divide family assets, and those can be defined, not just left up to the old definition under the Family Law Reform Act, and say that these assets are going to be divided up and this is how we're going to do it. Non-family assets are out. I have no problem with it because you've now given the parties a certainty that they're looking for in signing a contract. Otherwise, I'm afraid that it's just an invitation to future litigation. We were just barely getting used to the Family Law Reform Act before they changed it. And there are numerous cases dealing with definitions of what a family asset is. And of course, in Yolanta's contract that she's drafted, she's also dealt with a situation where there's been contribution, the type of old Section 8 claim, where the parties, one of the parties can make a Section 8 type claim. And then we're back to the Leatherdale type cases and the uncertainty. So I have some difficulty with the concept of doing it. I think Ruth Mesber talked earlier about how we try to tailor agreements to what the parties want. I think what we're also trying to do is provide some certainty. And if you're going to do a family asset, non-family asset split, I would think that you should delineate those assets which are family assets, let it be exhaustive, and say the other assets are out and they belong to the party who owns it.
Can I just add something to that? I think one way perhaps of dealing with that potential problem is to set out in a schedule of assets which is appended to the agreement these specific assets and describe them as these are the family assets the parties own at the date of the contract, so at least that there's some identification of what is being included within that definition. I think another problem, and I tend to agree with Harold in the comments that he's made about this type of contract, because this was a topic that was assigned to me, and it's not necessarily one that I would recommend to clients who might be entering into an agreement, is I think you also have to be very careful with respect to the definition of matrimonial home. The definition of matrimonial home under the old Family Law Reform Act would include a matrimonial home that was occupied by the parties at some point prior to a date of separation as a principal residence, and it may go further than the parties intend and include, for example, an asset that might have been occupied as a matrimonial home but then converted to a rental property. And unless one is very careful to ensure that the parties understand that the definition of family asset may go beyond what they're intending, I could see potential problems in terms of it catching assets that the parties may not want to have included at a later date.
Susan, have you any comments on that type of contract?
Well, I just have a general philosophical problem with if I was acting in a situation where there was a great disparity, or might be a great disparity in property between the two spouses. Why would one ever advise someone to give up all their rights under the Family Law Act and go back to the old Family Law Reform Act regime? But other than that, I also have substantial problems with how you would define some of these assets, and I think that it's just opening a whole can of worms to future litigation.
Yolanta, last comment to you.
I can see that this kind of contract would really only be useful in a very narrow range of circumstances. I think in a situation where the parties are perhaps coming into a relationship with not very much in the way of assets, perhaps not assets such as business assets that would need to be either protected or excluded from any potential sharing, the one benefit is that this at least recognizes that assets such as family assets are going to be shared equally as opposed to by ownership. And that may be something that might save future problems in terms of determining who paid for what or who contributed what to household contents. But when the range of assets becomes broader, or the assets that the parties are bringing into a relationship is greater, particularly where it involves business assets, I also wouldn't recommend this kind of contract being used.
Moving on to financial disclosure. Susan, when you're valuing or when you're dealing with the assets that the parties are bringing into the marriage or cohabitation, do you value them and insert the values in the agreement, or how do you deal with that issue? Some people, for instance, feel that if you start to value the assets and you're wrong, all you're doing is giving the other side something to shoot at if and when the marriage breaks down.
Well, this is a particularly large question on the issue of marriage contracts, and you have to consider particularly Section 56(4) of the Family Law Act, which specifically provides now it seems a positive obligation to make financial disclosure. Now, a couple of things to notice about that section. One, it's true that it's discretionary. The court has a discretion as to whether or not to set aside a provision in a domestic contract because of non-disclosure, and those provisions could be either property or support provisions. But it goes on to talk about failure to disclose significant assets or significant liabilities, and specifically the parties have no right to waive disclosure. So in answer to that question, yes, I would always ensure that there is disclosure. There's a case that would lead us to believe that not only must you disclose the existence of the assets, but probably also the value of those assets. There are three ways, in my view, to incorporate that into a marriage contract. One of them would be to put it in the background part of the contract or in the financial disclosure part of the contract. I would do that if you're talking about really non-property people. If you can simply say their incomes are such and such and their significant assets are their interests in the matrimonial home, car, and contents, basically. Anything more extensive than that, I would certainly ask that a schedule be attached with values in it. In most cases, you can estimate the values of the simple assets. Another way, when you can start talking about private companies or business interests, then usually, I think, if you're not getting an interest in the business itself, then the disclosure obviously isn't as significant. If you're getting zero of whether it's $500,000 or $50,000 or $1 million, zero is zero. So I might want the financial statements for the company, and definitely would for a few years back. If, however, my client was getting some interest in the business and we were trying to find out what the value of the company was now in order to determine what percentage of the increase in value he or she would receive in the future, then I would certainly want a more in-depth valuation and appraisal, and no doubt would consult an expert on that.
You mentioned when we were preparing for the program that there was a novel method of satisfying the obligation to produce value, or to produce financial information. Maybe you could share that with us.
Well, I was asked, as usual, the day before the marriage was to take place, to give independent legal advice on a marriage contract, and my client was absolutely penniless, of course, and the wife was quite wealthy. And her counsel satisfied the obligation by delivering me about a 6-inch thick, actually it was bigger than that, a 6-inch thick text of all of the financial documents that this man had, or the woman had, pertaining to all of her businesses, all of her trusts, just unbelievable quantity of material, and then wanted us to initial every page of this book in order to say that we had had complete financial disclosure. It was quite tremendous, actually, and well done, I thought.
How far do you, that raises another question, how far do you push for verification of the assets? Let's assume they give you a statement, a book of documents. How far do you want them to go to prove the valuations before you advise your client to sign?
Well, again, using that particular case, my client was getting 0 of 0, so I didn't really care very much. If he had been getting some portion of those, then I probably would have pursued it more. Now, on the other hand, I do say that you have to say to the other side, to some extent, in order to be able to advise my client on this marriage contract, I do need to know whether he is giving up his rights to $10,000 or $10 million, and to that extent, I must have some more disclosure than this.
Harold?
I think that there are two aspects of financial disclosure. One is just what Susan mentioned, that in order to properly advise your client. And secondly, for the contract to withstand the court's scrutiny if need be under Section 56(4) of the Family Law Act. But if you go back to basics, and when the client comes in to consult you about a marriage contract, generally what I would do is talk about what the Family Law Act is, the rights that one has under the Family Law Act and the Divorce Act, so my client has an idea of what they may be giving up. And then generally, I leave it to the parties to talk about what they want in general terms, what kind of division would be appropriate in their circumstances. If it turns out that you're acting for a husband who, say, has the assets, and he comes to you and says, well, my wife has decided that, or my fiance, that she doesn't want any part of my business assets or what I have coming into the marriage, then I recommend to my client very strongly that he put a dollar value to everything that he owns and put it at the higher end. If she's given up her rights to property, then best that it be at the higher end. It won't make any difference because it is very unlikely when the disclosure is forthcoming and is given to the other side's lawyer that the woman will then say, well, gee, I was prepared to give up my claim to your property, but now that I realize that it's worth so much, now I want a claim of to a share in it. I think that that would probably cause some problems in the relationship, and it would be unlikely that the woman would do that. So I would advise my client in those circumstances to always head for the upper end in valuation. I think that it is the legislation requires more than just setting out, I own these shares in ABC company. I think you have to come up with some type of valuation. The article that's been written by Professor Bala deals with how the courts have a certain distaste for premarital contracts, and I think to protect your client, you must put in as much financial disclosure as you can.
I think another reason why it's really important to have financial disclosure, particularly in the case of a contract which is only dealing with excluding, for example, the husband's business, and you have the right to make potential claims against the other assets under the Family Law Act. If the assets are specifically set out and the values are set out in the contract, that's going to establish the value of the deduction that the party is going to be able to take in calculating their net family property at the point of some later date of marriage breakdown. And this is something that quite often now, where you're dealing with long-term marriages, trying to establish the value of assets that the parties came into the marriage with is often very difficult, where you're looking back historically over 10 or 20 years and trying to determine what they might have had then. A marriage contract at least is going to give you some very good evidence of what the asset position was at the date of the marriage.
Moving on to release clauses for a moment. Susan, are there any dangers that you see in the habit that some lawyers have of simply taking the contracts that are drafted at seminars such as this and using them without giving serious thought to the implications of the standard form part of the agreement?
Well, there are many, many of them, not the least of which is that marriage contracts are relatively new, and while we've all taken shots at giving you precedents today, for example, things can change and case law can change rather drastically. But more important, I mean, I have a personal preference that marriage contracts should deal with what the issues are that the parties are concerned about. I really do have trouble with general releases as a concept anyway. I would like to see the specific items dealt with. But assuming you're trying to accomplish that, then, for example, if you're dealing with the type of contract that Yolanta was referring to with family assets and non-family assets, then you'd better read over your general release clauses and pay attention where you used to say net family property and start inserting other terminology. And another area of concern that comes to mind immediately is the support issue. If you're not having a release of support in the marriage contract, then, for example, you have to take a look at your estates release, the general estates release, because it says down there in one of the sub-paragraphs that you're releasing any rights to claim support against the estate as well, and that should obviously be deleted from the general release.
One of the other clauses that frequently crops up in agreements is a clause dealing with reconciliation. Now, perhaps it's a little bit far-fetched to be thinking in drafting a marriage contract of having a reconciliation clause included, but presumably at some point in time a spouse will say, well, what happens if we separate but only for a short period of time? One observation that I just throw out to you is that in one of the clauses that I've seen, it says that transfers of property are valid and subsisting, and the parties get back together again. None of the transfers are invalidated. But I wonder of a case where someone is brought in the matrimonial home, or sort of perhaps a better situation is where there's an agreement that the one spouse will acquire the interest of the other in a matrimonial home in a certain fashion, and then a reconciliation occurs. Do you then go back to the situation as it existed when the parties decided how they were going to share that home, or are you starting all over again? The point is only that a reconciliation clause being included where there is some possibility of a transfer of property having happened before the reconciliation clause kicks in is something that you should be careful about. Susan, again on the issue of things that tend to come up on a fairly regular basis, what of a situation where the home is being excluded, parties agree that that's to be the case, but the spouse who is to be the owner of the property says, now I want to be able to deal with this property during the time that we're living together. My spouse has no interest in it, and I want to be able to mortgage it or do whatever is necessary in order to fund my business, for instance. Is there any reason why you can't do that?
Well, there's some concern with respect to that as well. The Family Law Act specifically provides what can be included in these agreements, and certainly with respect to marriage contracts, it talks about ownership in or division of property. But the subsection under Section 52 states that a provision in a marriage contract purporting to limit a spouse's rights under Part 2 of the Act is unenforceable. So we always think of Part 2, or at least I always did till I looked at it carefully, as possessory rights. But it goes on, and in Section 21 is the section about the spouse's right to deal with the matrimonial home. And it says, no spouse shall dispose of or encumber an interest in a matrimonial home unless the other spouse joins in the instrument or consents to the transaction. And until I really looked at it closely, I had thought you could have that consent to the transaction in the marriage contract. So, for example, if the matrimonial home was in the husband's name and the wife was going to have no interest in it, and everybody knew that it had to be refinanced 2 years from now, you could put the consent right in the marriage contract, and you wouldn't have to get it later. There are those that would take a contrary approach and say that you can't do that. Now, I still think that if you can define the transaction clearly enough, you're all right, but I don't think that you can give a blanket, I no longer think you can give a blanket right to deal with the house.
Harold, anything to add?
I think that it is unlikely that a consent in a marriage contract could be upheld if the non-owning spouse tried to revoke the consent, and I think that they would utilize the provisions of the Family Law Act, which Susan just referred to, that you cannot limit your rights under Part 2. And Part 2 is not just the possessory rights, it's also the right to consent to transactions involving the matrimonial home. And the question is, I guess, whether or not a consent in advance is limiting your rights. Maybe it's not. Maybe all you're doing is just consenting to something. It's not a question of limiting your rights.
Maybe I can just add briefly to that. When that provision has come up in agreements that I've been involved with, while I say I think you might be able to do it in certain limited circumstances, I've also thought that it's very unwise and unfair. If a couple are living together and there are transactions going on with respect to the home in which they reside, I think as a matter of good marital harmony, they should at least be discussing it, and there should be some input from both parties on it.
I think there might be some strain when they come home and see the mortgage has gone up $15,000.
Yes, yes.
Ross, there was the other way of doing it, which was designating another home as a matrimonial home, which then releases that home from the operation of the Family Law Act. And I think that's something that comes up quite frequently. And then, of course, there's other ways around it. If you transfer the home to somebody else and put it in somebody else's name, then you don't have to worry about it. But I think you're looking for trouble, and as Susan just said, it's something that may be more of a social problem than a legal one.
One other suggestion that's been made in the area of marriage contracts is to draft a contract which contains a sunset clause. And that is to say that parties would sit down and decide what their relationship looked like it was going to be for the foreseeable future, and then provide that their rights would be thus and so for a fixed period of time. Yolanta, do you think that's of any use, or is that pie in the sky?
I think that may be very useful, particularly where there is a concern in terms of totally releasing, for example, claims to support. In fact, Harold and I just recently negotiated a marriage contract, which was, of course, one of these Friday before the wedding on Sunday last-minute agreements, in which the parties, it was finally resolved on the basis of having a one-year termination, except with respect to business interests and certain rights affecting the matrimonial home. In that situation, the parties acknowledged and it was understood that they were going to be negotiating and signing a more comprehensive agreement, but I had a great deal of concern that the agreement as drafted by Harold would have had the effect of forcing my client to release all her rights to claims under Part 1 of the Family Law Act, and we finally resolved it on the basis of putting in a termination clause.
When we were discussing things for this panel, I might say that contract came up, and I liked the way that Harold had sent it off to Yolanta. He said that it was simply preserving their rights as single people. In other words, Yolanta's client would get nothing. But it's a tactful way of putting it.
The problem is, of course, and it's been referred to earlier in the panel and sort of subsumes the entire discussion, is that how far do you go as the lawyer in dealing with these issues? And really, it's the clients who have to make the ultimate decision. You asked the question earlier, I think, Ross, to Ruth Mesber, whether she advises clients not to sign an agreement. And I quite agreed with her that it's ultimately up to the client. It's different from a separation agreement, I think, in that way, that the clients are going to decide between themselves, and as long as they do it with some knowledge of what they're giving up or what they're gaining by the legislation or by the contract, then I think it's up to them. And that's the final word.
Well, I think that if I can just use the chairman's prerogative, the final word I think has to be that if you get into the situation, you've just got to remember to report out to the client in some meaningful way, or I suppose if you're not into writing reporting letters or for some reason you can't get it to them before the wedding, you've got to have very careful notes. Paul Veda at the break made a comment that I think is instructive, and that is he participates in negotiating an agreement with the client, does everything that the client's asked him to do. 3 months later, he comes back and he says his friend Joe Blow down the street's got a contract with something else in it that's really nice. How come you didn't get that for him? And it's the kind of thing that I can see happening very, very frequently. They're going to come back and say, you know, here's something where you could have protected me better, and you're going to have to be able to protect yourself in that circumstance. Kathleen Metcalfe's comment about there never being a good time to negotiate marriage contracts is probably a good watchword, because the parties themselves don't want to have to do this. You can't simply let that carry the day. I wonder whether maybe we shouldn't adopt some of the legislation from, I guess it's the Ministry of Consumer and Commercial Relations. We should allow for a cooling off period on marriage contracts so that anything signed within 3 days of a wedding is not valid until sometime in the future, something to that effect.
I must say on that point, I really have difficulties, I'm sure all of us do, with the situation where you do get the marriage contract the week or 10 days before the wedding, and there's a wedding organized for 350 people, and either you sign the agreement or there's no wedding. I don't know what the courts are going to do with those in the future, but I have trouble with clients signing those. In spite of what Harold says, I have some difficulty in following the client's wishes when I know the client's only wish is not to be publicly humiliated by the fact that this marriage ceremony isn't going to take place.
Sounds close to duress. I don't know whether it's close enough. Susan, there are some contracts that have been floated around for discussion that state in the body of them that while they are marriage contracts, they will become separation agreements on the date that the parties subsequently separate. Do you see any reason why that type of an approach shouldn't be used?
Well, I'm one of those guilty of that. I tend to put those in my marriage contracts, and somebody will probably tell me why I shouldn't. But one of the reasons I put them in is simply for certainty. You know, I know the marriage contract will stand on its own and can be presumably enforced in court on that basis alone. But I figured if you state it to be a separation agreement, then it gives you that further enforceability perhaps with respect to the Ontario Enforcement Program. And also, I hope that it has the effect of making, if you've set out specific support payments in your marriage contract and it becomes a separation agreement, then I would hope that you would be able to receive the income tax deductibility for the support payments without the necessity for any further paperwork. That would be my reason for putting it in.
Do you think there's an argument, however, that an agreement of that type cannot be considered a separation agreement because at the date of execution the parties have not made that decision?
Certainly there is an argument that way, and no doubt it will be successfully made in many cases.
Yolanta, you wanted to add something?
I think another problem with it is because in marriage contracts you can't deal with certain things such as dealing with the custody and access of the children, that in the end result you may have to still negotiate a further agreement which is going to deal specifically with those types of issues.
And also with the possessory rights on the matrimonial home, but at least if you have the support going in there and it's tax deductible, that happens immediately while you're negotiating the other issues.
One final drafting point. Are there problems with an agreement that refers to the parties' children by previous relationships and says flatly that those children will simply not be considered as in loco parentis or the English equivalent? Harold, have you given that some thought?
I actually I drafted a clause that tried to accomplish that, where one of the parties had children and the other party was not expected to be a parent to the children in a legal sense, I suppose one argument is that you cannot contract out of that, that there's still this vague supervisory jurisdiction that the court has, and if the facts are that you are the parent of the child and you fit within the definition either under the Divorce Act or the Family Law Act, then the waiver notwithstanding, you are still on the hook potentially. The other aspect of it, I guess if one wants to look at it that way, is that if you really want to be careful, Stephen talked earlier about indemnities, and it might be that what you would want is an indemnity in that situation from the parent. That might be a more appropriate circumstance to ask for an indemnity from the biological parent.
I suppose it does indicate that at least at the time the contract was signed, there was no settled intention to treat the child that way, but I have some concerns about how that couldn't develop in the future. Susan?
I also think it's a worthwhile provision to put in as a statement of present intention, but I was more concerned about a recent marriage contract that came across my desk where it had been drafted by the Husband's Council, and he said in it that he would pay X percentage of his income towards child support, and the wife could stay home for Y number of years after the birth of the child, provided that the child was conceived with the consent of both of them. But if the wife went off and got pregnant without his consent, then she could stay home for half that amount of time and receive half the amount of child support.
We'll refer that to Judge Bala, or at least the former Judge Bala. That completes the planned part of our program. We'll go to questions now if there are any. Otherwise, you get out early. In the back? For the purpose of the videotape that's running, the question is what, in general terms, are Ontario courts doing with Quebec marriage contracts? I'll go first to Harold, then to Susan.
Well, I think that Professor Bala's paper, again, dealt with that issue. There were some cases that dealt with it under the Family Law Reform Act, and I think the courts, it's fair to say that wherever the courts could, they said it doesn't apply for one reason or another. The Quebec marriage contract was not intended to apply to the regime of property under the Family Law Reform Act, now under the Family Law Act. There is a case that was going on over at 145 Queen the last couple of weeks called Mittler and Mittler, in which that issue was being argued before Madam Justice McKinley. And one of the issues is the relevance of a Quebec marriage contract, and even if it does apply, whether the law of constructive trust can apply to the Family Law Act, and if it doesn't, whether the law of constructive trust can still apply notwithstanding the Quebec marriage contract. So I think that issue is going to be dealt with in that case. As of right now, it looks like it's arguable that the Quebec marriage contract does not apply to a separation that occurs in Ontario.
Or to which Ontario law applies.
To which Ontario applies.
Susan?
I have no further comment on it, really, except to again refer you to Professor Bala's article at page 94, A94 of your materials, which talks about the issue.
The case that is the current authority on the subject is by Justice Walsh, but I've forgotten the name of it. Kerr, that's right, the Kerr case, K-E-R-R. Yes, ma'am. The question is, are the indemnity agreements that the panel has referred to from time to time going to stand scrutiny? Stephen Grant, I think, put that in only partly lightheartedly. I think the intention of that section or that part of the program was to show that it's difficult to get around judicial decision-making or judge-made law. And it's probably worth taking a shot at, but I guess if it were me making the decision, you're right. If the whole agreement has to fall on some other principle, then the fact that you've provided for an indemnity will not, I think, add to the weight of your case. It is certainly used in other areas, however, where we're talking about property matters, certainly the obligation to reimburse for debts that are incurred contrary to the agreement. Perhaps in areas where the obligation is clearly drawn and the clause is clearly drawn, they will have some use, but I share your concerns about the less direct areas of support.
In fact, I know one lawyer who had a separation agreement that was pretty clear in terms of a release as far as support. The wife came back and sued, notwithstanding the release. The husband counter-petitioned, and I don't recommend this necessarily, counter-petition for a lump sum equal to whatever amount he was going to be required to pay to his wife. Obviously, it's circular, and indemnities may as Ross said, may go by the wayside. But in a situation where you have children from a previous marriage, the type of clause we were talking about before, say the husband has custody of the children, the wife says, I'm not going to be a parent to those children, and I want an indemnity from you. Subsequently, the children leave and go back to the first wife, and the first wife sues both of them for support. And I think that there's a recent decision of Master Cork which seems to give some credence to that type of claim. I think in that situation, an indemnity might very well come in may be useful.
Yes, sir.
Where one or both parties to the marriage contract have assets outside of Ontario, such as tax concerns or getting advice from a local solicitor in that jurisdiction about matrimonial law.
The question is whether there are special concerns with respect to assets held by the parties outside the jurisdiction. Yes.
I already spoke to the gentleman on break about it and suggest he ask that question again to pick my colleague's mind, so I think I'll pass over to somebody else.
Well, again, the law of Ontario applies to all assets, whether in or outside the jurisdiction, as long as the party's last common residence was Ontario, if I recall the structure of the Family Law Act. So I guess in general terms, you're looking to which was the jurisdiction in which they last had a common residence, and the decision then has to be made on that basis. The case recently that Stephen Smart was involved in with Malcolm Crombie, again, the name of which escapes me, the husband lived in Jamaica, as did the wife. The wife moved to Toronto. The husband was here from time to time, but it was a question of whether he had established a residence in common with her. The interesting result was that if the law of Jamaica applied, English common law from about 1935 would have given her practically nothing, and if the Family Law Act applied, she got substantially more. That case was decided on the common residence issue, and Ontario was seized with the issue. I would think that all of the assets are in, and what will frequently happen is that there may be a conflict between jurisdiction A and jurisdiction B as to which will apply, which I think is a very interesting issue to get into, but one that I doubt that this panel is prepared to deal with.
Can I?
Go ahead.
Sorry, I just wanted to add one thing. I think the case that you're thinking of was Prasad Singh,
Yes.
something like that. But I think there's two issues that are involved. Firstly, under the Family Law Act, assuming that the courts here have jurisdiction, there's no question that you can exclude property outside the jurisdiction from the calculation of net family property, etc. If there is property outside of the jurisdiction and what your concern is, yeah, fine, in Ontario, I'm all right, but who knows if I'm going to get sued in Mozambique or wherever the other property is. I think you should consult a solicitor in that jurisdiction and determine what whether this contract will apply to that jurisdiction, or whether it's going to be necessary to draw a separate contract in that other jurisdiction.
When I've been involved in that type of an agreement before, the concern really was valuing the assets for the purposes of the marriage contract, and the issue was what tax considerations would apply to the disposition of those assets in the other jurisdictions. And certainly for that, we went to get some tax advice from out of the country. But generally speaking, we then provided for the division of Canadian assets and the release of the assets in the other jurisdiction so that we wouldn't have enforcement problems.
Yes. You know, my suggestion would be that if you know the asset that you're dealing with, you simply exclude the asset from sharing by a specific term in the contract, which says that while you realize that otherwise it's a deduction, that you have agreed that the asset and any increase in value of the asset will be excluded. I thank you all for your attention. That's the end of the day.